separation of church and state, completely separated from issues of gay marriage, is something that Jews have been fighting to preserve for as long as we've been citizens in the United States, because we have always seen the separation of church and state not as a threat to Judaism, but as a protector of Judaism. Protector in the sense of allowing Jews to observe our faith as we have done for centuries, and to protect us from any coercion of an implementation of a state faith or any sort of coercion from the outside. So this is separation of church and state has always been something very, very important in all of its ramifications and all of its and all of the aspects of it. I'm a rabbi of a conservative synagogue here in Portland, and I say that because the word conservative is, of course, indicates that we're not reform, but conservative is not a political statement. It's really was an effort at the end of the 19th century by some more traditional rabbis to conserve Judaism from the more radical rabbis that they were concerned were really going to destroy Judaism. So it really wasn't a political designation. It really was a religious one. But anyone for whom the Bible is sacred has to deal with the book of Leviticus. And as all of you, I am sure, are aware, there are two verses that are very, very similar in the 18th and 20th chapters of Leviticus. That in the, let me read the second one. V'ish asher yishkav et zachar mishkavei isha, toeva asu shnehem. If a man lies with a male, the lyings of a woman, the two of them have done an abhorrent thing. I didn't write it. It's there. And the question is, what can we do about it? Well, first of all, that line, which becomes the basic line about the abhorrence of homosexuality, is actually a complicated line. First of all, it's clear that it only applies to men. Right? There's no reference to women in there whatsoever. And then, of course, the line, if a man lies with a male, the lyings of a woman. What in heaven's name does that mean? What are the lyings of a woman? Or as one lies with a woman? And therein lies a great deal of commentary. In Judaism, we have both the understanding of the biblical text itself, and then we have rabbinic commentary. The rabbis understood actually this line in a very, very limited sense as to what it restricts. And then in terms of its biblical understanding. And then there was rabbinic overlay, which prohibited all kinds of interactions, sexual interactions between males, and also prohibited lesbianism as well. In December 2007, the Committee of Jewish Law and Standards for the Conservative Movement, which is a committee of rabbinic scholars within the conservative movement, issued two contradictory rulings. The first ruling affirmed a 1992 decision that there was no way to conscience or endorse homosexual relations, a decision that was written by my own teacher, Rabbi Joel Roth. The second ruling was using a legal principle of human dignity. In Hebrew, it's called kavod habriot. It would be permissible to ignore the rabbinic laws, the rabbinic overlay that were added to the very narrow biblical restrictions. And this was researched by my colleague and professor at the American Jewish University, Rabbi Elliot Dorff, who was joined by two other rabbis, David Nivens and Avram Reisner. Now, what happens when there are two decisions that contradict each other? In other words, the second decision was saying there is no way, we have no basis for undermining that very limited restriction, but we do have a basis for overriding the rabbinic overlay. Rabbis were encouraged to study both of these rulings and to determine for themselves which was more determinative of Jewish law in their own judgment and for their own communities. The specific details are complicated and would go way beyond the purview of this symposium. As a result, I and many other rabbis, probably most conservative rabbis, affiliated with the conservative movement, have been willing to consecrate same-sex marriages. And a year ago, I officiated in Philadelphia at the wedding of my son Misha to his partner, David Connors. So I'd like to take Reverend Wilkins' comments about the problems that some ministers have in officiating at marriages where their religious denomination does not support it and turn it around. And for me, the question at hand is, from where issues the authority of the state to declare some weddings that I perform as a religious authority legitimate, and while declaring other weddings illegitimate. So that I officiated at my son's wedding in Philadelphia, which has Jewish legal standing, but has no standing in Philadelphia or anywhere else in the country. By the way, they got themselves on a plane afterwards, and in their jeans, got themselves married in California as well, the two of them. Perhaps I'd like to make a quick analogy between same-sex marriage and abortion. Since the issue of abortion remains so controversial, not only in society in general as to its morality, but among various religious groupings, it seems to me that the state of abortion today is appropriate, that the state should leave the decision to individuals to work out for themselves and with their religious leaders. And therefore the state should not take a position. And anyone for whom abortion is anathema shouldn't engage in it. All the more so when it comes to marriage, where religious leaders are not just functioning in a counseling role, but actually officiating at weddings, functioning in one of their primary roles for which they were both ordained and registered by the state. So I went through, actually it's very interesting, the state of Oregon has done some changes. When I first came in 1993, and for a number of years, in order to register as a religious leader, I needed a letter on letterhead from my congregation. I had to file to register, and I had to pay $10. And whenever a rabbi came to Oregon from out of the state to officiate at a relative's wedding, I would vouch for that person, and they would pay the $10, and that they were legitimate. The state of Oregon has given up on that entirely. They obviously found that too complicated, and therefore they are not registering religious officials at all. Anybody want to officiate at a wedding? It's all yours. You can all do that. But nevertheless, I am registered as an official of the state to officiate at weddings. And therefore, it seems to me that the state should allow me to determine what are legitimate weddings and not make that determination for themselves. Thank you.
We will have one final personal statement before I'll make a few concluding remarks and then open it up for questions and some answers. And so Bonnie Tinker is going to come up and give some of her own personal experience as well as her experiences with coping with this issue.
I am going to try in 10 minutes to tell you my personal history of why I am involved in this and why I'm one of the rare, peculiar, you might say, Beth, lesbian political activists who has believed for nearly 35 years that this is a crucial central issue, not only politically and in terms of rights, but personally and also spiritually. So here's how I happened to be working for marriage equality. It all started when I came out, and my mother, the first thing she said in horror was, "Oh no, and next you're going to tell me you want to marry a woman." And I, being a good feminist, said, "Heavens no, I don't ever want to marry anybody." Okay, that was 1971. By 1972, my girlfriend at that time gave me a Valentine's card that said, "Happy Valentine's Day to my wife," and I discovered that I was married. However, I did not happen to have any legal recognition of that fact, which turned out to be rather inconvenient. The next thing that happened is that same girlfriend said to me one day while I was at work, "Oh, we're going to adopt a child." I said, "Sharon, you don't say that one's cute, we'll have her." I was the oldest girl in 6 kids. I knew this was important. And she said, "No, we're going to." Well, it turns out we did. I went and met this child, and I held her, and I knew this is my daughter. And the way we adopted her is her mother gave her to us. A lawyer advised us that we didn't dare try to do anything very legal about this. We got a piece of paper from the birth mother saying she had been given to my partner because my partner said, "Go ahead, put the papers in your name because I know you'll take her away from me eventually." Such was the state of lesbian life at those times. And I said, "I don't need any papers to parent this child. I'm her mother. You put it in your name." Well, that got more complicated as time went on. So the first thing I knew is we couldn't have a legal adoption because we couldn't get married. We were lesbians, and legality was not ours. The next thing I learned when this same woman left me and threatened to take the child away from me was that I really needed to be married because I couldn't get divorced. I couldn't go to court and make the case why I was this child's mother. And I had promised this child that I was her mother. And I had no legal way to protect that. I had no legal way to resolve a relationship, to divorce this woman. And I lived in a community that was, you know, along with all the hets of the days, totally non-monogamous, except for me. Okay, so I knew marriage was important because I couldn't get divorced. The next time I decided to be in a relationship, I decided I was going to be upfront about this, that I wanted to be married. And this was my dear spouse, Sarah, who is sitting in the back. I hope not to embarrass her too much throughout this discussion. That was almost 32 years ago. And at one point early in our relationship, I said, "Oh, and by the way, I want to be married." And she said, "I don't believe in marriage. It's a sexist heterosexual institution. I'll have no part of it." Okay, we went from there. And my daughter was sitting in the back seat. She was 6 years old at the time. And Sarah said, "I'm not going to marry anybody." And my daughter said, "Oh, yes, you are. You are going to marry my mother." And I am happy to say that after 32 years, she finally acknowledged that, in fact, she had married me, whether we did anything formal or not. And in fact, in 2004, we had a wedding. But that's a long story, so and I'm supposed to do this in 10 minutes, so I'll try to hurry. In about the early 1980s, I was a Quaker. I was in meeting. We kept marrying people. I was on the committee that decided whether we were going to recommend marriages. And something snapped in me. And I went, I can't keep approving the Quaker meeting signing marriage licenses on behalf of the state when this is the very institution that is hurting my family. Because by that time I had 3 children, and I had seen ways that every one of them was hurt by our second-class citizenship. So anyway, I said, you know, and Quakers fortunately, function by consensus. That means you can't just outvote anybody. You have to get the whole ball of wax to agree. And so my saying, I can't do this, was taken seriously because our meeting couldn't marry anybody as long as I said, I can't say yes. And I really couldn't, because I realized that this was the institution where the legal piece of our oppression and the social piece of the oppression came together. And the legal people, even the political lesbian and gay people at that point, were saying, this is all just a legal civil matter. It really has nothing to do with churches. And so we really don't want all you church people involved in this, because this is really just about the law. And the church people were saying, well, we'll just have marriage equality right here in our Quaker meeting, and that should be fine. And I was saying, no, this really won't work, because it may be a legal institution, but culturally, it's going to the chapel, going to get married. That's where the culture is at. And most people who go off and get married don't do it because they want this list of rights. They don't even know what they're getting until they get married, right? This is where it comes together. And we as a community, me as a person, we have to figure out, where are we acting on behalf of the state to discriminate? Where is our spiritual wholeness? So I came at this completely as a piece of wanting rights for my family, but also wanting spiritual, personal wholeness for myself and for my family. From there, I worked with the Quakers to get them to not only approve marriage equality. We had our first lesbian wedding in 1989 here in Portland. The North Pacific yearly meeting, which is Oregon, Washington, Idaho, and Montana, agreed in 1992 that we would support marriage equality. That's by consensus, 400 people at a regional meeting. By 1995, we had come to consensus that we would support legal recognition of same-sex marriages. I saw that people could change, and these are biblical Christians. Not everybody knows that about Quakers because we are a little peculiar. But these are biblical Christians who came to unity that equality was the right thing in marriage. I meanwhile came across a few other reasons why it was important. One of those was from my son, Alex, who was here, but I think he may have left. One time when he was about 6 years old, there was a new kid in the neighborhood, and somebody said, and we were talking about Sarah, and someone said, who's Sarah? So I was going to go into some explanation of who was Sarah, and we were trying to stay a little cool in the neighborhood because we didn't want to mess our kids' lives up too much. And Alex said, oh, she's my mom's wife. Okay, so kids know. Kids know what marriage is. He knew who Sarah was. And I can tell you all of the stories that you've heard, the legal horror stories, the medical horror stories, all of the things that will not really be solved by domestic partnerships because if you go to another state, they'll still happen. But the bigger one is, for me, with domestic partnerships, we are still not married. And that M word matters. It confers social standing. It confers social acceptance. And you can't do it without it. Sarah and I actually both testified from a neutral point of view on the domestic partnership law, because we believe that you need to get what you can to protect your family. But we also believed that we won't be there until we have marriage, the capital M word, and that you have to do that with education, which I am so glad to hear that the rest of the LGBT community activists have now decided, let's go, we can actually talk people into this since we have to now. And I think we can. Anyway, the final story I want to tell you is I was on a talk radio program, a town hall with Alex when he was about 9 years old. And the commentator, the host, said to him, well, Alex, why do you think your mother should be able to marry your partner? And Alex said, on the air, I think my mom should be able to marry her partner so that I won't be a bastard. Okay. Yeah, that's what he said. This little kid nailed it. It's just like Stephen Green said. Our kids are the bastard kids today. What marriage does is confer legitimacy, literally. When the law changes and we can get married, our children will be declared legitimate. We can't get that with any other word. We can't get it piecemeal, and it's the most important thing about marriage, because marriage is about love and integrity, and it's about our families taking our place in society with full respect. Thank you.
Thank you, Bonnie. That was very moving. In fact, I think you really hit it on the nail on the head. When we're talking about the issue of gay marriage and why, and maybe Beth can talk about this a little bit more, if you have what, in essence, the Washington legislature has just enacted, which some people kind of jokingly called the Everything But Marriage Act, I believe is the term they used. Why is marriage that much more important? I was actually kind of like Tara several years ago when I had a gay assistant. And this was back in the mid-'90s. And he was advocating gay marriage back then and playing lawyer like you do when you can't escape it. And I said, you don't need to get married. We've got this thing called the Equal Protection Clause, and it should be applied to protect people's rights equally, non-discrimination. And this type of discrimination is irrational. And so I think the courts will finally get around to that, but you really don't need the marriage qua marriage. And in fact, that's going to be such a bugaboo for people on the religious right that they will never give up on that thing in and of itself. And so I found myself, unfortunately, kind of being patronizing, saying, as heterosexual, being patronizing of my gay assistant and saying, just kind of take what you can get, you know, with these rights. Well, I'm not as optimistic as I was back then, or as naive as I was back then, in that we do have a relatively conservative United States Supreme Court, and consequently, I don't anticipate coming from the United States Supreme Court any kind of landmark decision that is going to say that it violates equal protection to deny gays and lesbians the ability to marry, particularly because this is such a state law issue to a certain extent. But then also, I just don't expect it from the United States Supreme Court. But then also, I think, and I think you really did hit the nail on the head, it's also an issue of legitimacy. I'm teaching a class next year on what I call the constitutional history of the Civil War, and without battles. It's just going to be talking about slavery and the issues of Jim Crow laws and all this. And one of the things I was just reading over in preparation for selecting my books just the other day just reminded me once again that we enacted the 13th Amendment in 1866. We enacted the 14th Amendment in 1868. That 13th ended slavery, 14th is the major civil rights amendment we have to the Constitution. And what happened? Even though technically and legally African Americans were equal under the law, we entered into over 100 years of Jim Crow and segregation and discrimination. And that the legitimacy of their status was what was always being questioned, even though technically they may have shared many of the same civil rights that exist. And in fact, what's really interesting about the California Supreme Court, or California situation, the Prop 8, what created the Prop 8 controversy recently was, in fact, that the California Supreme Court struck down the domestic partnership law. California had one of the most progressive domestic partnership laws, had been enacted, and what happened? The California Supreme Court, in considering that, said, well, look, you being the state of California, have provided this list of rights that Beth was talking about, this list of rights, and basically every single thing that goes as a right with marriage you have now afforded to gays and lesbians. But you know what? It's incomplete. But you know what, California, you did? You shot yourself in the foot. By virtue of acknowledging that gays and lesbians were entitled to all of these rights, but the title of being married, you are actually engaging in discrimination because you have proven for us and to yourself that there is no legitimate, logical reason why gays and lesbians can't be married, why they can't raise children, why they can't have the property rights interests, why they can't have the whole host of rights. You've already given them to them. And so consequently, there's no real reason not to give them this most important last legitimizing aspect. And so that's why the California Supreme Court struck down the domestic partnership law effectively. And of course that then produced Prop 8. And it'd be interesting to see how the California Supreme Court, now that it's back before them, will deal with this issue. And they have kind of an interesting argument that some of the advocacy groups have raised, and I'm not sure whether the California Supreme Court will bite this argument, will take it on, but it's a good argument in some respects. And I think basically what the argument is this is different from other types of constitutional amendments, Prop 8, because constitutional amendments normally enhance rights. They normally expand the franchise, expand the opportunities. But this proposition does the opposite. It takes away rights from individuals, and it takes away whole-scale rights across the board. It's not discrete. It covers many, many rights that exist out there. And that's inconsistent with our notions of should we, in essence, give to the populace the ability to say, you can vote on this through referendum initiative to take away rights and privileges from individuals. I'm not really convinced the California Supreme Court will accept that argument, but I hope that they may. Well, one thing that does give me some hope, though, some optimism for the future, is I teach constitutional law at Willamette, and I'm finding increasingly when I talk about these issues in my constitutional law class that at least with the youngsters, I'm no longer one of them, the youngsters, the 20-some-odd-year-olds who are in law school, I'm getting back increasingly this kind of look from them and even statements from them of saying, why is this an issue? Why is this something that is going to continually be contested? And it gives me some hope that at least I'm sensing from more and more of our upcoming lawyers that they are going to see this issue as not really an issue. And so that's why I really wasn't surprised that the Iowa Supreme Court unanimously found that it was unconstitutional to discriminate against gays and lesbians by denying them the right to marry. And in essence, the law really is pretty strong. It just takes judges and individuals willing to have the, tenacity to get behind those laws. But I think there are really good arguments, and I actually do think, the panel may correct me, maybe you're more pessimistic than I am now, excuse me, but I really do think in the next 10, 15 years that this will come. The hard nut to crack, of course, is going to be the federal government because, in essence, it doesn't matter whether Oregon grants marriage rights like Massachusetts or whomever. There's so many rights that are tied to federal income tax, etc., that are tied to how the federal government responds to this. These are not portable, recognized marriages, take from one state to the other. And so consequently, that's why the federal government has to act. Okay, well, why is this a church-state issue? Well, the rabbi actually made reference to abortion. I think you could see a parallel to abortion. Abortion issues, in fact, I think gay marriage is the new abortion issue in some respects. But abortion issues can be a church-state issue, but I don't think they always are a church-state issue. Certainly the religious right, conservative Catholics oppose abortion. You find people on the left who support abortion rights. And so many times the dialogue and the rhetoric comes down and has a religious nature to it. And so in that sense, it is a church-state issue. In the same way you could say gay marriage is also a church-state issue like that. But then again, I believe that people can, in sincerity and with genuineness, oppose abortion without necessarily relying on their religious beliefs. I think there may be some people who would actually oppose abortion, or at least support regulations in some ways about abortion, who are not doing it for religious reasons. And in that sense, it's not a pure church-state issue. And legally, it's hard to go after it as a church-state issue. I'm not really sure that gay marriage fits in that same type of parallel, though. Because I think, as the rabbi really correctly said, there are some differences, even though people can oppose gay marriage from more religious perspectives and possibly from non-religious perspectives, as the same thing with abortion. When we're talking about marriage, though, here we have this institution that has, in essence, for the last 400 or 500 years, intertwined religion with the state. My father was a Protestant minister. And I can still remember sometimes when you perform marriages on Saturday night, and then on the way home from the marriage or whatever at the church, he would say, oh, we have to go by the post office because I have to go mail off the marriage license or else they're not really married. And you kind of like make a little chuckle like he's, they're actually sleeping in sin tonight because I haven't mailed the marriage license, ha, ha, ha. And even then I thought, this is kind of curious that a minister basically gets to determine whether in fact someone is married. And it really wasn't until recently that other people besides judges and clergy could perform weddings. In essence, it has always been the state recognition of certain types of religious rites, religious ceremonies. And so, to a certain extent, this is actually more of a church-state issue than even abortion because marriage under the law has always favored a particular religious perspective. It reaffirms not just social compacts, but also a religious type of compact in many people's minds. And so in that sense, it does take on that significance of being a church-state issue. Now, in just a couple of minutes, let me not play devil's advocate because I think these are important issues. I do invite you, though, when you think about this from a church-state perspective, to think about the complexity of this issue, though, because this is going to be complex. Because people within the conservative religious community are going to object to this for a long time, to gay marriage. In some instances, it will just be a visceral reaction. It'll just be they find this abhorrent, they find this offensive, they find this found in the book of Leviticus that says this is something that God will condemn. And so sometimes you have that. Just a couple of weeks ago, my center, where I'm at, we had a scholar come in to talk about the ex-gay ministries phenomenon out there. It's just fascinating that these evangelical groups who go and try to rehabilitate gays and try to turn them into heterosexuals and it's just a phenomenal, it's a very interesting phenomenon we have in this country going on. So sometimes you just kind of get these visceral reactions to it. And one of the most visceral, or one of the most, I think, artificial arguments we see from the religious community is that this is going to force people of faith, churches, to perform weddings that violate their own religious tenets. Well, there's not a person anywhere across the church-state perspective that has advocated that churches will be forced to marry gays if that's against their religious tenets. That is such a non-issue. It is such a red herring. No one is advocating that. Sure. Okay. A second one also is sometimes they argue it's also going to then take away the tax-exempt status of churches possibly. In essence, what happens? And some people may say that's a good idea, but anyway, what happens? When you recognize gay marriage, or even without that, under domestic partnerships or other non-discrimination statutes, which we have in Oregon, non-discrimination statute, that in essence it then becomes a public policy of the state to say that certain private individuals, private actors should not engage in discrimination. And if they engage in discriminatory practices, whether it's in employment, whether it's in housing, whether it's in what we call public accommodations, providing hotel space, rental property, whatever, these types of things, that in essence, if you engage in these types of activities, then possibly we will revoke your license, or possibly we will revoke your tax-exempt status. And actually there is a little precedent for that. About 25 years ago, there's a university some of you may have heard of called Bob Jones University. Bob Jones is a fundamentalist university in South Carolina, and they had a policy at that point where they first initially did not allow African Americans to attend, but then when they did not allow any interracial activity between African Americans and whites. That was against the public policy. It violated, at least technically, or at least on face, some federal statutes, and so they got their tax-exempt status revoked. And so I've heard within some of the conservative religious community, when this gay marriage issue comes up, this is one of the first, little scare things that come up. Say, well, look, also, churches, religious organizations that will abide by their religious beliefs. And let me make sure you understand me. This is sincere religious faith among many people. I'm not disparaging their religious beliefs. These are very strongly held religious positions that to a certain extent help identify who they are as a religious person. And to a degree, it has parallels to the way gays and lesbians and the rest of us self-identify. This is a way people self-identify by their religious beliefs. And so they do raise concerns that they will somehow then be forced into situations with which they disagree. And it does. There can be a host of issues out there. Those first two, I think, are pretty bogus. We're not going to force ministers to do marriages with which they disagree. We're not going to take away tax-exempt status of churches for failing to perform gay marriages because they do a host of other things that are probably against the public policy anyway, and we don't take away tax-exempt status for that, too. But if you do think, once you start talking about all the non-discrimination statutes and laws that are out there, there are some concerns that the religious community, conservative religious community, is going to be raising that we have to at least take seriously and we have to at least consider. And maybe in some instances we may need to accommodate some of their objections, some discrete objections they have to whether they would be forced to participate in certain types of activities. I'm not trying to give you a litany at this point, but let me just give you a couple of examples. When, after Massachusetts, the Massachusetts Supreme Judicial Court required gay marriage, then Catholic Charities of Massachusetts, which had an adoption program, they then declined to go forward with their adoption program because under the way the new law was instituted, they felt that they would be required to place children in gay and lesbian households. Now, we may all say, so what? But for people of faith, at least within this particular religious community, this was something that they thought violated their religious tenets. And so in order to prevent them being regulated or being sanctioned, they then said, we will have to get out of this business. Okay. There may be other types of adoption services available that may not necessarily be that much of a problem. But we do have a host of religious organizations within this country, hospitals, nursing homes, social service agencies, that do a host of public social services that are going to be pushing back on this issue because they're going to be saying we may be forced to compromise our religious tenets if because these rights are recognized, then we will have to do something that goes against our religious tenets. I'm not saying give full exemptions, but it's just a perspective that we need to keep in mind. This is a very complex issue that is coming up. And even though the James Dobsons out there are going to bring out the scare card all the time and say the sky is falling, and he is easy certainly to disregard, there will be some concerns raised by the religious community that we're at least going to probably need to sit down at the table and talk about and say, are there ways that we can accommodate each other, but still not standing in the way, of course, of gays and lesbians to have that ultimate fulfillment that the law, at least the federal law in most states, still deny them, and it's still not a marriage, notwithstanding what possibly the Washington statute says, or at least tries to be.